To help you better understand what happens in a small claims case, King County District Court has produced several brief videos. In this video, Judge Laurel Gibson discusses what to expect at the small claims trial.
The person who filed the small claims lawsuit is called the plaintiff, and the person, business, or organization being sued is called the defendant. The court will schedule a small claims trial after two required steps have been completed. First, the plaintiff must prove to the court the defendant was properly served the notice of small claim. In other words, the defendant needs to be officially notified that they are being sued. This topic is discussed further in our small claims service video.
Second, before a small claims trial is set, the court requires plaintiff and defendant to participate in mediation with the King County Dispute Resolution Center.
Mediation provides an opportunity for the parties to meet and discuss the problem and to potentially settle the case outside of court. King County District Court requires both the plaintiff and the defendant to appear in person at the courthouse for small claims trials. Small claims trials are less formal than court cases you may have seen on TV or in the movies. The focus is on speed, efficiency, and fairness. Instead of a jury, the case will be decided by a district court judge. The small claims trial will last about 40 minutes. Each side will have about 20 minutes to prove to the judge why they believe they are right. In a small claims case, you must show by preponderance of the evidence that you are right. This means that it is more likely than not. The judge will need to decide whether the plaintiff or the defendant is more likely to be correct after they have presented their side. This is a lower standard of proof than beyond a reasonable doubt standard that many of you may be familiar with from criminal trials. If you are presenting a claim or counterclaim, you will need to prove three things to the judge. 1, how much money you believe you are owed. 2, why you believe you are owed the money. And 3, how you calculated the specific dollar amount that you think you are owed. If you're responding to a claim or counterclaim, you will need to focus on proving why these three things are wrong.
For example, you may try to show why you do not think you owe the money to the other party, or why you do not think you owe the full amount of money for which you are being sued.
Both parties must provide their evidence to each other at least 14 days before the small claims trial. You will need to bring 2 copies of any evidence you want the judge to consider. And evidence is anything you think proves that you are correct. For example, evidence could include letters, voicemails, text messages, invoices, contracts, pictures, and more. And if you have a witness, you can either have them attend the trial with you or have them file a written sworn statement.
If your evidence is audio or video, you will need to bring a USB thumb drive to court with you, along with a copy for the court.
You may not use your cell phone to present digital evidence because any evidence presented to the court must be retained for appeal. After the plaintiff and the defendant have presented their cases, the judge will issue a decision. If the defendant wins in a small claims trial and there is no counterclaim, the court will dismiss the case. If the plaintiff wins or the defendant wins their counterclaim, the court will issue a money judgment, which is a court order saying that someone owes somebody else a certain amount of money. The money judgment specifies the amount of money that is owed, and this can include the amount of the claim or counterclaim, as well as reimbursement for certain eligible costs such as the court filing fee and costs for service. The judgment includes interest that accrues daily based on the type of claim. This means that the longer someone takes to pay the judgment, the more money it will cost them. The judge does not order a payment to be made right there and then in the courtroom.
The party who won their claim or counterclaim may have to hire an attorney and pursue other court proceedings such as liens and garnishments to collect on the small claims judgment.
Additional information on small claims trials can be found on the King County District Court website or the Washington Administrative Office of the Court's website.